So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about the GDPR and its impact on emails and reading emails in the workplace. So the General Data Protection Regulation or the GDPR emerged as a response to the growing concerns over privacy and data protection in the digital age. Its roots traced back to the European Union's Data Protection Directive of 1995, which set out basic principles for data protection but didn't have the enforcement power or the uniformity necessary to address the evolving landscape of data privacy. In 2012, the European Commission proposed a comprehensive reform of data protection laws to modernize and strengthen data protection across the EU. After several years of negotiations and discussions among institutions, stakeholders, and member states in the EU, the GDPR was officially adopted in April of 2016 and came into effect 2 years later. Representing one of the most significant advancements in data protection regulation globally, the GDPR aims to harmonize data protection laws within the EU, enhance individuals' rights over their personal data, and impose stringent obligations on organizations handling personal data. And I would argue that it's one of the strongest employee rights that employees have in the EU. There's just a lot of reasons for it. We'll be talking about one of them today, but I think I'll do a later video on the nature of this. So the GDPR has several implications, including lawful processing of employee data. Employers have to make sure they have a lawful basis for processing employee data, such as performance of contract, compliance with legal obligations or legitimate interests. They have to have transparency and fairness with how the data is collected, processed, and used. And they also have to only collect and retain employee data that is necessary for the purposes for which it is processed. In addition, they have to have security measures. They have to have data subject rights, which includes the right to access their personal data, the right to fix it, and the right to remove it, or the right to be forgotten. And then they also have data breach notifications. If employers are required to notify the relevant supervisory authority if there's any data breaches within 72 hours generally. In addition, if an employer transfers employee data out of the EEAA, the European Economic Area, they have to make sure that there's safeguards in place. And as a result, GDPR really has to make employers to take proactive approaches to data protection. And it's a really key point in this world, specifically on data protection and the employer. So within the context of employee emails, individuals get the protection of their privacy, and as a result, it means the confidentiality of their personal data. So information that's actually in private emails is contained within the GDPR, and as a result, any processing requires the fulfillment of one of the provisions of the GDPR. The employee's consent is actually not justification, as the employee is assumed to be sort of a subject of the employer, so they can't give consent in real life. The employer's overriding and legitimate interest is particularly relevant. There has to be a balance struck between the employer's legitimate interests and the rights of the employee themselves. And so all review of employee emails is through this lens with respect to the balance between these two powers. And the balance really here becomes from business use and private use. So if only private emails are allowed or if only private emails are prohibited, employers can assume that whatever is in the mailboxes of their employee is specifically work emails. And so if they're only sending work emails from their work email, there is, a reasonable understanding that it is a justifiable overriding legitimate interest. But it's different if the business email allows or even tolerates private emails in the mailboxes. If they allow that, then the employer has an interest in, when the employer has a legitimate interest in accessing the data, it may outweigh the employee's interest in confidentiality. And as a result, the inspection might not be authorized. Similarly, if the employer assumes that mailboxes contain necessary information relating to communication with customers, They have to they need to inspect to ensure business operations continue, and ultimately the employer's interest would outweigh that of the employee. If the employee could, understand and expect an inspection because, for example, they could access their predecessor's mailbox, and that's really one of the key points to GDPR. Is whether or not the employee has an understanding that they are going to have privacy. And if they don't, then the business could call into question. Now, I'm going to talk at a different time about all of the things that the GDPR provides as employee protections in a video to come soon. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.